Oh. Okay. Before we begin, let me introduce some members of town government that act as advisors to this board. To my left is Paul Hennings, counsel to the board. To his left is Peter Hans, senior planner in the planning department. To his left is Tom O'Brien, a planner in the planning department. Now let me tell you why you're here tonight. New York State statute requires that any town that adopts zoning must also have a board of appeals to act as a relief valve, so those persons aggrieved by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers such as special exception approvals, site plan approvals. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception uses. The most common kind of application before the board are area variances. Area variances deal with dimension, such as lot area, frontage, height, setback, and parking spaces. New York State statute mandates that the board must consider the following criteria in area variances. When you come to the podium to present your application, you need to address these 5 areas. They're posted here for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created. And number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interest of the applicant and those of the community or neighborhood. This statute further requires that the board shall grant the minimum variance it shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Special exception applications are different than area variances. When you have a special exception before us, I will explain the difference. Regarding procedure, cases will be called in order that they are advertised. When your case is called, please come forward, submit your affidavits and mailing receipts to Mr. O'Brien, and then you will be sworn into the podium and you will be given the opportunity to explain to the board why you need the variance. After the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity to be heard. So please organize your thoughts. Keep your remarks factual that are related to the case. Then I will ask the applicant to come back to the podium to answer your concerns. The board will then close the case and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of the case. Number 1, you can wait until after the public hearing, but there's no guarantee the board will act on your case tonight. Number 2, you can call the planning department tomorrow afternoon. And 3, the applicants can wait and be notified by mail. We do have some adjournments, so let me tell you what the adjournments are. The first case is case 16688. Geraldine McMillan is adjourned to June 12th. Is there anyone here that was interested in that case? Okay. The next case that is adjourned is case 16669, Frank Aiello on 27 Elderwood Drive, St. James. Anyone interested in that case? That is adjourned to June 26th. Okay. The first case for tonight, case 16689, Michael Brown, 3 Spinnaker Court, Fort Salonga. Location, west side of Spinnaker Court, south of Fort Salonga Road, Fort Salonga. Property zone R43. Request variance to permit environmentally sensitive land to be altered, slopes greater than 15%. Permit structures within 10 feet of any slope greater than 15%. Retaining walls and bocce court. Reduce setback of a retaining wall from property line from 3 feet to 0. Increase the maximum height of a fence retaining wall from 6 feet to 9 feet. Reduce the distance of a fence to a retaining wall from 4 feet to 0. Increase the maximum paving in the side yard from 25% to 55%. Good evening. May I have your name, please?
Michael Bonacasa.
And Michael, do you have a power of attorney?
My client is here.
I
but
need your client first.
Okay. I do have a power. No.
Hi, ma'am.
Hi. May I have your name, please?
Michael Brown,
And your address, Michael?
3 Spinnaker Court.
Okay. Fort Salonga?
Yes, ma'am, Fort
Okay.
Salonga.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. Now, would you like this gentleman to speak for you?
Yes, ma'am.
Okay. Can we get that microphone so that is, you're going to? Okay. I'm going to ask your name, and I'm going to ask you to spell your last name, all right?
Michael J. Bonacasa. B as in boy, Onacasa.
Okay. And your address?
575 Broad Hollow Road, Melville, New York,
Okay.
11747.
Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. You want to tell us why you're here, please?
Good evening. I'm here representing Michael and Renee Brown, who live at 3 Spinnaker Court, for the variances previously stated by the chairman. The item number 1 pertains to the paved area in the rear, in the required side yard. I just brought a board just to point out some items. The major portion of the paved area is the existing driveway that was installed prior to my client purchasing the home. That area here represents about 45% of that 55% that's listed in the variances. The area that was newly constructed,
Take the mic out, maybe it's easier for you. How's that?
the area that was newly constructed comprises the west side of the pool, which is approximately 450 square feet, which is only 10% of that yard. It is there really to access and maintain the pool. In my opinion, it's set back so far behind the existing home that is really de minimis in nature for that side yard requirement. Items number 2 and 3 pertain to the existing slope of the property. The applicant filed for and received a permit to build a new cabana. And when we filed the final survey, these items came up about the retaining walls and the slopes of the property. My client thought he was landscaping in conjunction with the new cabana when these items came up. Item number 4 pertains to a retaining wall that was constructed by a previous owner and was in place. That's here on the north side property line, indicated in yellow. My client has no plans on altering it. It's just going to remain in place. Item number 5 and 6 pertain to a retaining wall that separates the yard down the center, right down here. And the issue is that the retaining wall is 3 foot 8 inches high, and on top of that is a 5-foot fence. The 5-foot fence is the requirement to enclose the pool area for protection. And when it's put on top of the 3 foot 8 wall, it's 8 foot 8, where 6 foot is required. The issue of setting it back off the wall, 3 foot 8, so that it would be, which is referenced as item number 6, would create a narrow section of land, 3 foot 8 up, which would be difficult to maintain. And it would also propose a danger. My client has young children, and he feels that kids could get up there and they could fall off the wall. So by putting the fence right on that wall, it keeps them from getting to that space. This item is down the center of my client's yard, and we feel that it really has no adverse effect on anyone but himself. I mean, in my opinion, the intent of that particular ordinance is to really reduce that heaviness of a wall on perimeter sides of the property. And this is really something that's on the interior of the property that my client is really the one that's affected by that. Okay. With regard to the 5 points, the variances would not produce an impact on the adjacent properties or the neighborhood because the alterations will not cause excess stormwater runoff to adjacent properties. The sloping areas have been flattened, and this will allow stormwater to have a better opportunity to percolate into the ground on the site. Now, our north property line, which is the low side of the site, is not being altered in any way. That's from the previous subdivision. I believe the request is not substantial. The entire construction area on the site is less than 20%. The benefit cannot be achieved by an alternative because moving the bocce court and down to that lower area of the site would take away area where he has some play area for his kids. You know, it's a flatter, leveler space, but he really has that there for the kids to play soccer and baseball and have catches. The land itself had a small slope on it, and basically by modifying, you know, this area, it created a more usable yard. The variance would not cause an adverse effect on the environment because the lot was cleared and developed prior to this application. The owner has only reconfigured the space, as I said, just to make the yards more usable for his benefit. The difficulty, we feel, is not created by the applicant because the sloping in the property was there when the property was purchased. The pool was also there. So to create that area around the pool and the cabana, these things had to be done to really make that yard more usable. I'd like to submit a few pictures of the yard that were taken this morning.
We do have many pictures that we have gotten in the file.
Okay, these were just more current if you...
That's all right.
Okay, I'll keep them here.
That's fine.
Basically, what I wanted to show you that the yard is kept in pristine condition. I don't know if you went by the site. The landscape is kept beautiful. My client has spent a considerable amount to make this yard something that he can be proud of. And I think the improvements only serve to better the community and just enhance the beauty of the neighborhood. For these reasons, we respectfully request that the board grant our variance.
Okay. Let me just clear up a few things. Number one, your client is responsible, even though he bought the house with the 55% of paving. And we look at it as if it wasn't there. So I don't know what happened when he went to contract, but you know, he is responsible for that and the retaining wall.
Okay.
Okay?
Okay.
That doesn't mean that we'll deny or approve, but I just want you to know that we will look at it as it was, you know, it's not being there.
That's fair.
Okay? Planning?
No comments, Madam Chair.
Gentlemen? No. Okay. Thank you so much. You're welcome. Was there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Greatly moved in second. All in favor?
Aye.
Motion carried. Next case is case 16690, Indian Head Family, LLC. Location. This is next to the Superior Ice Ring. It's west side of Indian Head Road, south of Ellen Place, Kings Park. Property zone RMGA. Request variance to permit environmentally sensitive land to be altered. Slopes greater than 15%. Permit structures within 10 feet of any slope greater than 15%. Reduce setback between principal building from 32 feet to 22, 30 feet to 22. Reduce side yard setback from 60 to 30, and total side yard setback from 120 to 75 for 36 apartments units, totaling 28,880 square feet. Increase the maximum building height from 35 feet to 39. Increase the maximum permitted number of stories from 2.5 stories to 3. Increase the maximum permitted number of units from 8 to 12 per building.
Good evening, Madam Chairwoman, members of the board. Vincent Pizzulli with offices at 333 Earl Ovington Boulevard, Uniondale, New York, for the applicant, Indian Head Family, LLC. At the moment, my site plan engineer is not present. We can proceed without him, but I'd like to, I have a map here. Maybe planning can help me out. We can put some maps out so the board can follow. I don't know if you have maps in your folder or not.
We have them.
Yeah. Okay. Before I begin then, I'm going to hand up some documents to help the board follow the presentation. The first handout is an aerial photo of the property, which is marked out in red, and so the board can see the site in context with the surrounding area.
Thank you.
Also, let the record reflect, Madam Chairwoman, that I handed up the affidavit of mailing and the affidavit of posting to Mr. O'Brien. The next document I want to hand up before I proceed are copies of the Town Board change of zone approval, which approved the rezoning of the subject property to RMGA. That was on December 13, 2011.
Thank you.
The last document for submission are copies of this Board of Zoning Appeals approval of our prior variance application for the subject property. The decision was dated November 25th, 2009, in which the Board of Zoning Appeals granted our request for environmentally sensitive land variances and a lot area variance. Okay, I think that's everything. The subject property is a 3.79 acre parcel located on the west side of Indian Head Road, approximately 1,470 feet south of Ellen Place. To the south of the subject property is the Superior Ice Rink, which is on property zoned light industrial. To the west is Country Point, a residential development, condominium development on property zoned R6. To the north is an industrial building on property zoned light industrial. I want to explain a little bit about the prior history of this property and application so the board has the whole picture tonight. The site was originally zoned light industrial and was rezoned to R6 Townhouse on March 29, 2007. At that time, the applicant planned to develop 20 townhouses and subsequently applied to this board for a lot area variance and variances to permit the alteration of environmentally sensitive lands. I believe I handed up to you, Madam Chairwoman, the copies of the approval of the environmentally sensitive land variance. The BZA approved that application on November 25th, but the housing market had deteriorated by then, and the condominium project was no longer feasible for my client to pursue. Going back to the 2000 change of zone approval, the original change of zone approval for the R6, at that time the town board required the applicant to design predominantly smaller, more economical one-bedroom units in order to make the units more affordable to first-time home buyers and senior citizens. In its memo to the town board at that time, the planning department also indicated that it would support a request for RMGA zoning on this property if the units were also proposed to be smaller and more economical, regardless of the form of ownership. Consistent with the planning department's recommendation, the applicant petitioned the town board to rezone the subject property to RMGA, which would allow for the development of 36 apartment units in 3 buildings in the same layout that was previously approved for the R6 development. The planning department again recommended approval, and the town board rezoned the property to RMGA on December 13th, 2011. I have handed up to you a copy of the town board resolution of approval with conditions, and one of which I want to point out for the board because it's central to our presentation tonight. The town board rezoned the property to RMGA subject to, among other things, utilizing the exact same layout that was previously approved for the R6 project and the original R6 development project, which was the site plan that you see in front of you. It was basically a site plan with 3 buildings in the same place, which is graded and into the hill to minimize disturbance of the steep slopes. In the change of zone approval, the town board also required a minimum of 26 one-bedroom units be designed into the 3-building layout. That approval was based on the concept that smaller units, whether they be rentals or co-ops, will provide more affordable housing options for town residents for whom the average single-family home is either unnecessary or too expensive. Because the units will be smaller and more economical to build, there is no need for any government subsidies or regulations to mandate affordability. The proposed development will be a market rate project. I was going to tell you that our site plan and elevations are on display, but they're not, so I'll skip that portion of the presentation. Turning to the variance request, they are all driven by the topography and configuration of the property, and the town board's requirement to use the same layout that was previously approved for the R6 development. The side yard variance that we're asking for, which is a reduction to 30 feet on one side and 45 feet on the north side, only for building 1. That's the only building that requires a side yard variance of the 3 buildings. That variance became necessary because the zoning changed from R6 to RMGA, and when you use the same layout, there's a different setback standard in the RMGA, hence the side yard variance request. The request for a height variance, which is also on building 1, and a variance for the number of units per building are necessary in order to achieve the permitted density of 36 units in 3 buildings. The town ordinance requires in apartment developments and multiple group developments that units be limited to 8 per building. Our proposal has 12 units per building because we're limited to 3 buildings. If we were to plan another building, we would be able to comply with that, but we're not going to be able to comply with that because the town board wants to minimize the disturbance of the steep slopes and keep all the apartments in 3 buildings. Similarly, the height variance, which is on building 1, that is driven by the same thing. In order to get 12 units into that building and have a total of 36, we had to, instead of having 2.5 stories, we had to go to 3 stories. And on that portion of the property where building 1 is situated, we had originally designed a retaining wall around that building to keep it within the 35-foot height requirement. The engineer found a way to eliminate the retaining wall, which is a good thing in our estimation, but in order to do that option, it requires a height variance of 3.2 feet. We're requesting 39 feet on a requirement of 38, on a building height of 38.2. And that's because of the slope of the property. As it slopes downward, the front elevation is measured from grade, and it'll be slightly higher in the front than it is in the back. I'm sorry, yes, in the front than it is in the back. The setback between buildings variance wasn't identified on the previously approved R6 site plan, but that dimension is the exact same dimension that's on the plan before you tonight. For some reason, that variance wasn't called out. When this board previously approved our variance application, there was a 22-foot setback between buildings 2 and 3. It's the exact same setback on the plan today. So we probably would have been coming back to you anyway for an additional variance at that. The environmentally sensitive land variants are the same as those that were previously approved by the BZA for the R6 site plan. It's the exact same layout. It's the exact same grading, fill, and disturbance. The variance will not produce an impact on adjacent properties because the proposed development is consistent with the residential character and zoning of adjacent R6 development. It's high-density residential housing. And it's compatible with surrounding non-residential uses. If you'll notice from the aerial photo that I submitted, the property to the south is the Superior Ice Rink. So our side yard setback of 30 feet is really to the boundary with the ice rink, and there's a parking lot between us and the building. And having visited the site today, I can attest to the fact that it'll be very, very minimal impact to the residents of this particular project, and no impact to the ice rink at all. On the north side of the property is an abandoned, or I shouldn't say abandoned, it's a vacant industrial building. Okay. The setback to that property will be 45 feet. It's heavily wooded along the property line. It's heavily wooded along both property lines, so both properties will be screened from our property, and our property obviously will be screened from both of the industrial uses on both sides. We are bordered to the west by the Country Point development and the rear yards of 1 or 2 of the condominium buildings at Country Point, which are set back at least more than 100 feet from the property line and probably at least 200 feet to the nearest structure on our property. We believe the request is not substantial because the subject site is 3.8 acres and can support the proposed development in accordance with all RMGA standards except side yard. Compliance with side yard standards will not achieve the best possible site design and layout. In other words, we could probably figure out a site plan that complies with all of the RMGA standards, but it wouldn't be this site plan, and it would require more coverage of the site and more disturbance of the steep slopes. And I think it was the town board's and the planning department's intention to keep the development into 3 buildings. The benefit cannot be achieved by an alternative because the proposed site plan, as I said, is the best possible site design and layout for the subject property. The variances will not cause an adverse effect on the environment because all sanitary waste generated from this project will be collected and treated in an on-site sewage treatment facility, and disturbance to steep slopes will be minimized. The difficulty was not created by the applicant or former owner because the difficulty stems from the existing topographic conditions and the conditions of the change of zone approval. At this point, I'll pause and ask the board if they have any questions.
Okay, that's it. Planning?
Nothing, Madam Chair.
Gentlemen? There are no questions. Okay? All right. Is there anyone here that would like to be heard on this application? All right. One up, please. Excuse me, first of all. Excuse me, just a minute. If there is anyone else, please, I'm going to ask you to line up. All right, may I have your name, please?
Emil Serrata,
Spell your first and last name.
EMIL
Okay.
SUHRADA,
Okay, and your address?
98 Manitou Trail, Kings Park.
Okay, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do. Okay.
Okay.
I'm, I guess, a resident of Country Point, which is directly behind the proposed project. You know, it seems to us that this project is kind of increasing in scope since we supported it on the first go-around. We initially thought it was a good idea as compared to that castle or catering place that they were going to do. Was going to be townhouses. Then it went a little further. Now it's a little further. I think my main concern right now, other than the increase in scope, is that on the plan that we received, which is probably not the current plan, one of our members received a plan from the lawyer showing a leaching field. We were under the impression or understanding that the first 50 feet between us and them was going to remain sort of pristine with the trees and such to block or screen the view of the proposed project, which was acceptable. And now we noticed on the plan that we received that they have a leaching field that goes all the way back, leaching manholes that go all the way back on the plan that we see, which I was told is the current plan and which was not shown on the original plan. It seems to me that this leaching field, to put these manholes in and the associated pipes, would have to kill all or a good portion of the existing trees in the back, reducing the screen to very minimal amount of trees left.
Okay.
So we object.
Okay. All right, thank you.
All right?
Thank you. Anyone else, please line up so that I know you're going to speak. May I have your name, please?
Stanley Salmirs.
Spell your last name, Stanley.
S-A-L-M-I-R-S.
Okay. Your address, please.
104 Manitou Trail, Kings Park, New York.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. Okay, as my neighbor pointed out, the original plan that was submitted in 2011 was one that we felt was a good plan and agreed to. Now, with some of these changes, we feel it's going to affect the integrity of our area. One of the main problems was pointed out about these leaching fields. Now, that means that they have to cut down the trees in order to institute these manhole covers. And in doing so, it's going to leave, the tree area they had between our house and the new construction. And we object to that because we feel it does infringe on our, our architectural integrity. So that's what I wanted to point out.
Thank you so much. Okay. Anyone else? Okay. Ms. Bazil, I'll ask you to come back up.
First of all, I'd like to, and I did speak to Emil on the phone. He called me. I had gotten a call from one of Emil's neighbors, Neil Rosenberg, and he had asked me to send him a copy of the site plan, which I had done before, but I said, sure, if I have one in the file, I'll send it out to you. And I did. I mailed him a file, and unfortunately, Neil and Emil, and I apologize to you, you were the victim of the same thing I was a victim of. We had a site plan in which the site plan engineer, and I'm not speaking this way because he's not here, I would say it even if he was here, he didn't call out all the variances in his notes on the site plan. In fact, when we submitted for the denial letter for the Board of Appeals application, I called out the environmentally sensitive land variance in the side yard. The planning department, when they looked at the plan, they didn't see the other variances initially because they weren't written out on the plan. But we figured it out, Peter and I, and we got an amended denial letter and made sure that the notice of the hearing was proper. However, obviously in the interim, I had sent Neil a copy of the site plan that didn't show all the variances, so that caused some confusion. And I hope that I was able to explain tonight that the additional variances are due to the nature of the zoning changing from R6 to RMGA. I think the bigger concern, and they are correct, the bigger concern is with the area to the west or to the rear of the proposed location of the STP. The site plan that you had in front of you is showing some leaching fields immediately behind the building and to the south of it. I spoke to the engineer about that, and he said that the Suffolk County Department of Health Services is making it very difficult for him to find another location for those leaching fields, but we're still working on that. Okay. In any event, when the town board approved the change of zone, they left open the site plan review, and we didn't memorialize the depth of the buffer as a condition of approval. However, if we have to remove any of the existing natural vegetation to locate any of the required leaching fields, we will restore the vegetation. We're permitted to replant the area with mature trees. It doesn't have to remain an open, vacant area. These are underground leaching fields that can be installed, and the property can be revegetated to do that. So we can and will maintain our commitment to maintain as much of the natural vegetation between the STP and the Country Point property. But it's going to be a function of site plan design.
Okay. All right. Just let me make it clear to everyone, no? Sorry. That there is no action tonight. Okay.
I have one question, Mr. Pizzola. The leaching fields that you show on the drawing that you presented tonight, that's worst case scenario. They're not going to go further back towards the neighborhood.
Correct.
It'll only it'll stay there or get better.
Or get better, correct.
Right, thank you.
Okay, thank you. Okay, I'll entertain a motion to close the hearing.
So moved.
Greatly moved and second. All in favor?
Aye.
Aye. Motion carried. Okay. No, we're ready? Okay. Next case is case 16691, Philip and Maria Messina, 22 Ramsey Road, Comac. Location, west side of Ramsey Road, north of Weldon Lane, Comac, property zone R10. Request variance to reduce minimum side yard setback on west side from 12 feet to 2 feet 7 inches for an existing 306 square foot carport. Reduce the total minimum side yard setback from 28 feet to 15 feet 7 inches for a 16 square foot first floor addition. Decrease the distance from any lot line from 6 feet to 4 feet for a 6 foot to 16 inches for an existing 177 square foot accessory structure. And your name, please?
Phillip,
Oh,
Messina.
Okay. And your address, Philip?
22 Ramsey Road, Comac, New York.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay.
The three items we're going to discuss, one was a 16-foot extension on the north side of the split-level house. It doesn't extend beyond the chimney of the house. It's consistent with the design of the home. The carport is 306 square feet. It was placed on the south side of the house. I'm asking for a setback variance for the carport. The carport is consistent with the design of other carports that are in the area, as well as the shed, which is 177 square feet. I'm asking for setback adjustments on that also. The design of the shed is consistent with that of the main house, and actually has been there for quite a number of years, and I think adds to the community, and is consistent with the other structures that I've seen in the area.
Okay. Just let me tell you that we go to all the sites.
I'm sorry?
We go to all the sites, so we were at your home. Was that the shed in the back there that you consider a shed? It was originally a garage?
No, that
It was never the garage?
No, I put the garage door on it.
Oh, okay, and it's just a shed?
It's just the shed.
Okay. Let me just tell you, I don't know how the board is fair, but 2 feet to your property line for a carport is very substantial. So I don't know how the other people on the board feel about that, but it's very rare that we approve a carport that close to the property line.
I'm requesting the variance.
Okay.
I've seen it consistent with other homes in the area. So, again, I'm requesting your approval.
Okay.
The
Planning?
carport's been up for a significant number of years and never had any complaints from anyone in the neighborhood.
What brought you in then?
What brought me in is I want to make sure everything is correct on the house property, and had the house resurveyed. And in case we decide sometime to sell, everything is squared away for my wife.
Okay. Planning? No comments, Madam Chair. Gentlemen? Okay, thank you.
Thank you.
Is there anyone here who would like to be heard on this application? Okay. Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second?
Ready, moved, and second. All in favor?
Aye.
Aye. Motion carried. Next case is 16692, James Ryan, 20 Eklund Boulevard, Wisconsin, location, south side of Eklund Boulevard, east of Agard Lane, Wisconsin, property zone R10. Request variance to reduce the minimum front yard from 40 feet to 35 for a proposed 180 square foot roof over front porch. May I have your name, please?
My name is James Ryan,
And your address, James?
20 Eklund Boulevard, Nesconset, New York, 11767.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Yes.
Excuse me? Should be in there.
We got this. This is good. We just need one more sheet. Looks like.
Do you have an extra one?
Using the application.
Let's see if it's in a box. Well, I'll let him fill it out and then,
This is what we need, along with the
wait a minute, did she find it?
Oh, good. Okay, yeah, fill it out and then, at the end. He's got it.
But he didn't fill it out. Okay, fill it out, let me hear the, yeah, but I have to have an attorney sign it. Jean, can you sign it for us? Okay, thank you, all right, come on up to the podium. All right? Yeah. Okay. Okay,
Sorry about that.
that's all right. Now raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay. Tell us why you're here.
I'm here to obtain a variance for my property. I had a front porch put on, like a front porch with the roof that I really didn't know. I'm a first-time homeowner. I didn't know I needed a permit. And when I tried to get one, they said I couldn't get one, I needed a variance. So that's why I'm here.
Okay. Planning?
No comments, Madam Chair.
Gentlemen?
No.
No. Okay, pretty easy.
That's it?
Yeah.
Painless.
Thank-
Thank you very much.
Okay. Is there anyone here that would like to be heard on this application? Hearing now, I'll entertain a motion to close the hearing.
So moved.
Really moving second. All in favor?
Aye.
Motion carried. Is it Oster or Oster? Next application is case 16693 Oster Avenue Associates LLC. 145 Plant Avenue, Hopog. Locations outside of Oster Avenue, east of Plant Avenue, Hopog Properties LI. Request variance to permit environmentally sensitive land to be altered, slopes in excess of 15%. Permit structures within 10 feet of any slope greater than 15%. Reduce the minimum lot area from 80,000 square feet to 76,307 square feet due to slopes. Actual lot area, 8,507 square feet. Increase the height of retaining wall with fence from 6 feet to 7. Proposed 29,190 square foot industrial building. Hello.
Good evening. My name is Michael Marinas. I am the engineer for the project, licensed professional in the state of New York.
Where is there an applicant here?
The applicant is not here. I previously submitted a letter from the applicant authorizing us to make the
Do you
application.
have a power of attorney?
Do I have power of attorney? No.
I can't hear the case. I'm sorry. Yep, I cannot. You have to have a power of attorney.
I had spoken already to someone in town, so that it's not
But the applicant didn't. And the applicant,
The applicant has to be here.
or he has to be the, what do you call it, the president or the vice president of the organization, of the
Even though I have the
corporation.
letter.
Even if you have the letter.
Or a power of attorney.
Or a power.
He couldn't be here tonight.
That's why a power of attorney would act as substitute, and you would be able to speak for him.
Okay, even though we have a letter.
Sorry, I'm sorry, yet we have to comply with the general obligations law.
Okay, just let me know where is that, what's the section of the law that I'm starting to get?
I would just recommend getting a Blumberg power of attorney form.
Okay.
That would work.
Okay, can we get scheduled?
Okay. I'll give you June 12th. Okay.
Okay, so if he can't be here, then just a different letter.
It's not a letter. It's, you have to get it's,
Otherwise, if he's here, then it's not.
yeah, it's not. Where can he get the power of attorney?
No, he just wasn't able to be here tonight, so.
Oh, fine. Either or.
Okay.
Okay?
Thank you.
Thank you. Yeah. Yeah. Yeah, repost, okay? You get a new. Okay, it has been adjourned to June 12th. Next case is case 166. Wait a minute, just before I do that, was there anyone that was interested in this case? Okay. Next case is case 16694, Octavio Capana. Its location is west side of Lawrence Drive. I believe it is on Lawrence Drive in Nesconset, north of Blackwell Drive, Nesconset, property zone R15. Request variance to increase the gross floor area from 25% to 33%. Reduce the minimum rear yard setback from 60 feet to 53 for a proposed 5,197 square foot two-story dwelling.
Good evening, Madam Chairwoman, members of the board. Appearing on behalf of the applicant, Eugene L. D. Nicola, 200 Railroad Avenue, Sayville, New York. Madam Chairwoman, let the record reflect that I have submitted the affidavit of posting, the affidavit of compliance with notification provisions, and the return receipts to Mr. Hans. Now, the applicant is requesting two variances. First, an increase in the maximum permitted gross floor area from 25% to 32.51%, and to reduce the rear yard requirement from 60 feet to 53.5 feet. For the purpose of constructing a two-story single-family dwelling on the premises described in the call of the meeting. Now, the subject parcel is a vacant lot on a filed map known as the Map of the Pines at Nesconset. The map was filed May 8, 2006, in the Suffolk County Clerk's Office, map number 11382, and this is lot number 7 on that map. The area within which this parcel of land is located is predominantly residential in nature. However, to the east of the map, the file map, is the Barella nursery property with its greenhouses and so on, growing hothouses, greenhouses, whatever. This portion of Lawrence Drive ends at a cul-de-sac just north of the subject parcel. The cul-de-sac ends at Smithtown Boulevard. Lawrence Drive ends at Smithtown Boulevard. Now, as we all know, the economy has deteriorated, and it did so shortly after this map was filed and the improvements completed. So it has been a long time and a long period with regard to completion of the development of the lots on the map, and this is one of the lots that will be developed if the board approves the variance request this evening. The subject parcel is on the west side of Lawrence Drive and contains 16,245 square feet of area, and it is in the R15 residence zone. As indicated, the applicant proposes to erect a two-story single-family dwelling, which will meet all of the dimensional setbacks with the exception of the rear yard. Now, the rear yard setback proposed is 53.5 feet, and it is at a point on the dwelling which is only 12 feet 8 inches wide, and at that house, it's a break in the back, if you will, for a breakfast area on the house plan. Now, I believe plans have been submitted to the board along with the application, so you may be familiar with the plan and the house. The survey also indicates the way the house has its breaks in the rear, this being the rear yard. Additionally, I believe a plot layout was submitted showing the manner in which the subject parcel abuts the two parcels on the west. Lawrence Drive runs north-south. Cul-de-sac is slightly north, a couple of lots. This is the subject parcel which I have highlighted. Perhaps you can see it. And then the two houses on the west, which front on Southern Boulevard, are on either side, so that the center of the house actually is at the property line between the two houses on the west. It is not directly behind any dwelling at the rear. So there is a good distance. When you go out from the 53.5-foot setback to either side of the proposed dwelling or the breakfast area, the rear yard extends to 55 feet, and then 18 and 20 feet on either side. It increases to the full 60-foot rear yard requirement. So it's that one short portion that we're talking about for the 53.5-foot setback. The manner in which the house is laid out and the rear yard request does not create a close proximity between the dwellings to the subject dwelling and the dwellings to the east. The setbacks from the dwellings on the east to the rear line, to the common rear line, is 71 feet and 75 feet respectively, and that would, of course, exclude the swimming pool on one of the lots. And Madam Chairwoman, I trust the board does have this layout?
Yes, we do.
Thank you. The dimensional distance between the dwellings is extensive, probably in excess of 130 feet between the dwellings. The dwellings which have been previously constructed on the lots on the file map have and are extremely attractive, as is the proposed dwelling by the applicant. The proposed dwelling will enhance the value and appearance of the neighborhood, and the minor variance request this evening should not detract or create an adverse impact to the area. The board has granted other gross floor area variances on this file map. Lot number 6, case number 15465, the FAR, or the gross floor area, was increased to 31% from 25. Lot 8, case number 16330, to 29%. Also, a minimum and total side yard variance was granted for lot number 4, case number 16232. Now, the applicant is constructing a single-family dwelling in the R15 Residence District. It will therefore not produce an adverse impact or detriment on the neighborhood, nor change the character of the neighborhood or create any undesirable change in the neighborhood. The required variances are not substantial in relation to the requirement, and considering the prior variance relief granted by this board on the other lots, it should not be considered a substantial relaxation as requested. The applicant, if it wishes to construct this dwelling, cannot do so without the variance relief requested from this board, and no adverse effect or impact will be created to the environment or the physical conditions of the area, since only a single-family dwelling is being constructed on a parcel of land which is zoned for single-family dwelling use. Now, although the issue of self-created hardship may be applicable, it is but one issue to be considered by this board in its deliberation. Any self-created hardship is minimal and negligible in the instant case. On a balancing of the equities, the board should favorably consider this variance request, as there is no detriment to the health, safety, or welfare of the neighborhood. Actual circumstances and its effect should be considered rather than any type of reliance on just, let's say, plain or bald statistics, if you will. And Madam Chairwoman, members of the board, I would respectfully request that this board favorably consider the variances this evening.
Okay.
Thank you. If there are any questions?
Just a couple of questions. First of all, I'm looking here, I'm looking at the first floor, the second floor. I believe the attic is 470 square feet. Am I correct?
That could be true, Madam Chairwoman, yes.
Okay.
The actual building is probably 31.97 feet, but when the building department denied the application, they included a balcony, which is part of the internal structure, which is about 84 square feet. So the house is really 31.97 feet, but they do need the additional relief because of the balcony, which again is an integral part of the structure.
Okay. I'm going to turn it over to planning, but the other thing is, did you read the, from the DEW, the report from DEW?
No, I did not see one.
Okay. They're asking for the minutes because it seems to them you have a cellar entrance. Did you have this?
Can I have a
I'll tell you 1 second, Madam Chairwoman.
So they want him to address that?
He wants to be able to get in the cellar.
Yeah, there appears to be a cellar entrance on the north side of the dwelling. I have a cellar entrance in my house. It's
I know that, it just says,
easy to bring me out
residential use with the cellar space coupled with the large side of the proposed dwelling may result in an adverse environmental impacts.
Well, I find that hard to believe. It's a basement.
Yeah.
Every house has a basement.
Yeah, generally, the concern environmental department has is that it would become possibly an illegal apartment, that sort of thing.
There's no chance that Mr. Campagna is going to have an illegal apartment in this house. You don't erect a house like this to rent an illegal apartment.
So let me turn it over to planning, but I just wanted you to know there's no action because I don't have a secret.
I understand. Thank you, Madam Chairwoman.
Okay.
The comments that the planning department just wanted to make was the home directly to the south was before this board as well. It's almost identical in size. The lot area is almost identical in size as well. They were granted a variance with including the attic area. That comes to 32%. Without the attic space, that home would be about 29%. The subject property that we have before us is approximately 33% with the attic. If you deduct that airspace in the attic, that's 29%, so it's very close to that. The lot directly to the north of that was also before the board. They're 31% with the attic, 27.3 without the attic. And there's one other home in the subdivision that didn't need a variance. It's under the 25%. However, it's on a very large parcel, and the home is over 7,100 square feet. So we feel that even though the home is very large, it is in keeping with the board's prior approvals.
Okay. Gentlemen, do you have any questions?
Or detriment to nearby properties will be created by granting this area variance. The proposed development of the project site is in conformance with the surrounding industrial uses and existing zoning. There will be no detriment to nearby properties following the development of the site with the variance. Item 2, whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than the area variance. The environmentally sensitive lands, the slopes, are located through the middle of the site. Their location severely limits the ability to develop the site without disturbing the slopes or areas within 10 feet of the slopes. Whether the requested area variance is substantial, the requested variance represents approximately 10% of the property, and the minimal slopes are unsubstantial. Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. The proposed variance will not have an adverse effect or impact the physical and environmental conditions of the neighborhood. The proposed development is consistent with the uses of the surrounding properties. And lastly, whether the alleged difficulty was self-created. The difficulty posed by the environmental sensitive lands was obviously not self-created, as the slopes naturally exist on the site. If you have any other questions with regard to those variants, I'd be happy to answer it. The only other issue before you tonight is the variance for a retaining wall. The existing slopes on the property are such that it was necessary to slope or essentially cut the property and try to balance the site. So we have retaining walls on both sides, approximately 4 feet in height. However, because we wanted to add a safety railing on top of the retaining wall, we're proposing an additional 30-inch railing, which puts us over the 6-foot limit. That's all I have this evening.
Okay. Planning? Gentlemen?
No, ma'am.
Okay, thank you so much.
Thank you again for your time.
Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
It's really moved in second. All in favor?
Aye.
Motion carried. We'll go to the adjourned hearings now. Case 16526, Joseph Legabo, 28 Pulaski Road, Kings Park. Location, south side of Pulaski Road, west of Main Street, Kings Park, property zone CB. Request a special exception to maintain an accessory apartment above an office. Variance to waive a special exception standard that requires adequate lot area. Waive special exception standard that requires parking. Waive special exception standard that requires adequate buffer. Reduce buffer to resident district from 10 feet to 2. Reduce minimum parking from 12 to 7 spaces. Reduce minimum truck loading spaces from 1 to 0. Reduce the minimum drive aisle width from 20 to 11. Reduce the minimum parking setback from 6 to 0. Reduce the rear yard setback from 50 feet to 45. Permit principal building with no frontage. Reduce distance between two principal buildings from 30 feet to 20.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. First off, I'd like to hand in a permit from the health department with respect to the sanitary flow, which was recently obtained. I know that Howard Barton would want it. We've already delivered it to him, and I'll give you a copy.
Do you have the, is there a folder in here? You have the folder? We have it here.
Are you ready?
We're just getting.
Oh, okay.
Go ahead. Go ahead. We've been here before.
The applicant, Joseph Legalbo, purchased this property in 1987. He purchased it from a gentleman by the name of Diana. And when he purchased the property, he also, unbeknownst to him, purchased a few problems. And those problems were not disclosed to him at the time that the property was purchased. Mr. Legalbo, Joseph, is going to speak on that because I think it's important for the board to know that since 1987 to date, the property has existed basically as it is today, with the main building, an apartment on the second floor, and a small office built into what we call the garage area. During all of that time, there has never been a problem with parking. There has never been a problem with excessive use. We also have tonight the tenant that rents the small garage office, as well as Mr. Legalbo's son Anthony, who's an attorney, and ultimately intends to use the office, use the main office to conduct his legal practice. The other thing I'd like you to be aware of, which I'm sure you are, the properties along Pulaski Road generally are 50-foot wide, so that the a lot of the variances that we're requesting are necessary only because that's the way the lots were laid out probably almost 100 years ago. So I think it would be best at this point to have Mr. Legalbo speak and tell you what happened and why he thinks that this board should grant the variances. Joseph?
Wasn't this all in the record before? Mr. Tramarko, wasn't this all in the record before when we heard this case?
No, I don't think Mr. Legalbo spoke.
I spoke briefly at the last meeting, yes, but there are a few issues I'd like to discuss since then.
Okay.
I know it's been a long
Okay,
meeting.
let me just swear you in then.
Okay.
Okay. Let me have your name and address.
My name is Joseph Logalbo. I reside at 33 Meadow Glen Road, Fort Salonga, New York.
Raise your right hand. You swear to tell the whole truth and nothing but the truth?
Yes, I do. I know it's been a long evening, and I hope I'll keep this brief. It's just 2 pages of basically a little presentation that I have. And I hope that planning doesn't take offense to this, but obviously I'm going to respond a lot into what they had in suggestions, because what I had received from them recently, or actually since the last board meeting, because they hadn't submitted their report. So a lot of what I have is kind of directed at some of their suggestions or proposals. That's why I say what I'm about to say tonight probably doesn't pertain to my last time here.
Go ahead.
I would like to bring to the board's attention that planning repeatedly mentions myself as the applicant in the 1986 board approval, when in fact it was the previous owner, John Diana, who was the applicant and one who misrepresented the board's condition of approval at the closing. It was he who recommended the removal of the garage and not the recommendation of planning at the time, and it was my lack of due diligence which has led to this predicament. Had I been aware that the removal of the garage would have been a condition of planning, I never would have purchased this property from the beginning. so I was misled from the date of the closing. Unfortunately, Mr. Tramarko was not the attorney at the time. Planning states that parking is insufficient with regard to the 7 stalls we have provided. I find it hard-pressed to look throughout the town of Kings Park and see a business that would meet such parking requirements. One only has to visit any of the establishments along Main Street or the corner of Main Street and Pulaski Road to experience this fact. Planning's recommendation to move the second office building does little to accomplish the ease of parking on any places, ease of parking and places a financial burden on the applicant, further complicates setbacks, and achieves little or no desired result. I bring to the board's attention that meeting ADA requirements was not part of the 1986 approval, and as such, do not see this recommendation being more permissive than their previous approval as indicated in their findings. Planning further indicates the benefit to the applicant outweighs the detriment to public health, safety, and welfare. I bring to the board's attention that for the past 25 years that I have occupied this premises, there has not been one documented incident to substantiate this claim, nor a complaint by anyone in the community. In fact, the community has benefited by me providing living accommodations, business opportunities, and real estate revenue. Revenue which I have been paying since June of 1987, when the assessor's office more than doubled my taxes when improvements were made. The widening of the driveway that planning has recommended in its site design only removes a street parking space and does little if any good to the site plan. It only removes a beautiful red maple which exists on the property and further establishes the property as a commercial building in a residential setting. If I may, I do have photographs of that nice red maple. If Anthony would present those.
All right. Are they labeled?
Yes, they are. They're labeled and named.
Okay. We've all been to the property, so
Okay.
we all know, we're
thank you.
well aware of the property. Thank you.
May I continue? Paving requirements further distinguish this property commercial in appearance, whereby the existing bluestone driveway conforms to the residential setting and functions as a natural runoff of rainwater. I asked the members of the board if any of you have ever attempted parking in the rear of the bakery in Kings Park or the Fort Salonga Shopping Center after a heavy rain. Flooding and pooling is so severe as to make sections impassable. Once again, time has proven my current arrangement to be adequate, conforming to the surrounding houses, and the fact that I have never had an issue with pooling, flooding, or runoff problems only proves my point. The Department of Waterways questioned my architect's calculations of the existing sewerage flow requirements. After costly fees to engineers, architects, testing agencies, and application fees to the Board of Health in the amount of $5,500, it was discovered my existing system has functioned flawlessly. So much so that the overflow was bone dry to the surprise of myself and the testing agency. Yet, the Board of Health is requiring that I redesign the system and plumbing to eliminate piping bends and conform to distance requirements for setbacks from adjoining property and buildings for an additional cost of $5,000. I understand that the board, along with Planning, Department of Waterways, and the Board of Health, require these modifications for what they consider to be for the better good of the community. But I bring to the board's attention that at times they stifle growth and place undue expense and hardship on small businesses that in the long run prohibit the very goals they seek. I know the board has to take into consideration that their decisions are made not only as to the applicant at hand, but for any future business that may occupy this premises. It is for this reason I remind the board of my first opportunity to speak before you. At that meeting, I indicated it was my hope that someday my sons, who at the time were both attending Brooklyn Law School, would occupy this building and continue to contribute to the community as I have for the past 25 years. While I am proud to say that my oldest just graduated and has passed the bar both in New York and New Jersey, and my youngest will be attending his final year next semester, I would like for the board to give him the opportunity to say a few words on my behalf. Thank you for this opportunity to present my case before the board, and I know that in your final decision, you will consider all the facts as presented. Do you have any questions?
No.
Okay, thank you.
Let me
Ms.
have your
Board, good
name,
evening.
please.
Anthony John Legalbo. My address is 4920 39th Avenue, Long Island City, New York, 11377.
Okay, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
I so do.
Okay.
Madam Chairperson, members of the board, members of planning, good evening. Again, my name is Anthony John Legalbo. I wanted to first thank the board for taking the time to hear our family's case, and I promise I will be brief. I understand that the board is quite busy, and both my father and I value your time and consideration in this matter. I'm a native-born Long Islander and a 2004 graduate of Kings Park High School, and as my father mentioned, 2011 graduate of Brooklyn Law School. I currently practice law as an attorney of counsel at a small startup civil litigation firm called Kane O'Connor. Kane O'Connor is a boutique construction litigation firm that consists of myself and 2 senior associates. We provide legal services for general contractors and subcontractors. We're a new firm created on January 1st, 2012. All of our clients are based in the 5 boroughs in Westchester. My firm is unique in that we have no formal offices. Approximately 4 days a week, I make appearances in the 5 boroughs. Any and all office work is done via a firm server from the comfort of my current apartment. It is my goal to practice law at the subject property. The location is ideal for my practice. Though small, the office will provide me with basic support services. The majority of my week is spent abroad, attending proceedings and meeting with clients in New York City. Therefore, the office will serve primarily as a formal address for the purpose of receiving mail and accepting service of process. Aesthetically, the structure will remain the same. The building will continue to remain residential in appearance. Since my target client base is located in New York City, there will be no need to advertise my firm via external signage of any sort. Additionally, because my client base is located entirely in the 5 boroughs, I will not entertain clients at this location. Therefore, egress and ingress will remain at current levels. My intended use of the property is in line with my father's current use. UCD is conducted without interruption for an excess of 25 years. The board can rest assured that the subject property will continue to conform with the surrounding properties, thereby preserving the residential aesthetic appeal of the surrounding properties. I'm aware of the recent trend, and the board is working closely with local businesses to grant exemptions of the type we have requested today. Our case is exemplary of this trend. Moreover, by obtaining Board of Health approval, our application stands distinguished from prior applicants. Absent an exemption of this type that we have requested today, both my father and I will be unable to conduct business at the subject property. Thank you for giving my family the opportunity to be heard on this matter. I value both the board's time and careful consideration. I hope that I was able to provide the board with additional color as to the current use and intended future use of the subject property. I am certain the board will weigh the facts presented and arrive at a decision based on the totality of circumstances. Moreover, I ask that when deciding this matter, you exercise your discretion, a discretion that the town of Smithtown has empowered you with to address unique situations such as this. And in doing so, I ask that you take into consideration both the unique nature of the property and the unique nature of our family's business. Thank you.
I'm just going to call very briefly. We have the 2 tenants that are on the property. And the purpose is to indicate to the board the no necessity for any increased parking. The first tenant I'd like to call is a CPA, Mr. Baumritter. He occupies what we call the garage area.
My name is Michael Baumritter.
Spell your last name, please.
Baumritter.
All right, and your address?
55 Lake Bridge Drive South, Kings Park, New York, 11754.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes. Well, as he just said, I'm a CPA. I've been a tenant in that second building for 9.5 years. Now, in all that time, I have never seen more than 3 cars in that parking area or driveway at the same time. Usually it's 1 or 2 cars. I have a small practice. Most of the times I do not have any clients or anybody coming to my office. I'm not there all the time. I usually come in the afternoons and evenings, but not every day. And Joe Logalbo, the owner, he's also a CPA. And the same goes for him, except he usually comes in the mornings, and he's gone by early afternoon. And he has very few clients or anybody come to his office. And there's the one tenant upstairs has a car which she parks on the property at night, but she's usually out during the day. So there's really, there's almost no more than one car there at a time. And this is in 9.5 years. I can't see the need for really any more parking than what exists. And the driveway appears to be adequate to me. It fits in with the surrounding properties. It seems to me if it was widened and blacktop, let's say, it would change the whole character and the whole look of the property, and it really wouldn't fit in. And as I said, both Joe Legalbo and I have very small businesses, and there's not much traffic at all. It's been very quiet in the 9.5 years I've been there. I've never seen any problems. Property is well maintained. I've never seen any flooding or anything like that on the driveway as it is. And basically, I'm in support of everything that Joe has said about the property.
Thank you very much.
So thank you.
I'd like to call Maria Fairchild. She is the tenant of the upstairs apartment.
Let me have your name, please.
Maria Fairchild,
Spell your last name
F as in Frank, A-I-R-C-H-I-L-D.
and your address.
28 Pulaski Road, Kings Park, New York, 11754.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do. I wasn't here at the very beginning, so I don't know exactly what the issues, what has
Right.
been
Just tell
discussed
us,
with the,
yes.
about driveway. I have never seen any flooding. I've been there 2 years. I've lived there 2 years. I work, I'm self-employed. I work a few hours at home, and I also work off-site. I don't have clients visiting me. Like Mike said, the most cars I've ever seen there at any time is 3 cars, and I could count on the fingers of one hand the number of times that there have been that many cars. I'd also say that within the neighborhood, there are houses of a similar size and similar plot sizes with twice as many cars as that. We're less impact on the neighborhood than a lot of properties on that block.
Okay, thank you.
Mr. Legalvo would just like to point out one thing.
All right, please.
Yes, when my architect presented the plans that you have, he made an error in the calculation of the parking requirements. He had indicated that the accessory apartment required 2, and based upon the board, there's only 1 parking requirement for an accessory apartment. I'd just like to note that. Also, what I'd like to note, too, is that although that there is a calculation for the cellar of 1.4, I mean, the cellar is a mechanical cellar. Basically, what we're dealing with is a boiler and a hot water heating system. So, I mean, a parking requirement of 1.4 for a cellar, although I know it has to be in the plans, I just want to state that. But we can reduce the requirement from 7 to 11 by adjusting the accessory apartment to 1, which I think I do have the code section if you want that.
No, thank you.
Also, with respect to the basement area, I was just speaking to Anthony, and Anthony's 5'10", and his head can touch the beams. So the ceiling is less than 6 feet. It couldn't be used for anything but mechanicals.
Yeah, it shows 5 foot.
Okay.
Oh, okay.
Right.
We don't feel that this will make an undesirable change in the character of the area because it's been around basically since 1987 and before. Can we do this application in some other fashion. No, we really can't. It's existed, it's worked well, there hasn't been any problem for many years. Whether the variance is substantial, we don't think so. If you think about Kings Park and how everything is laid out, not only along Pulaski Road, but Main Street, they're all small properties. That's the way it was done. It was laid out probably 100 years ago in a grid fashion, much like the city of New York. So this is what we're kind of stuck with when we try to improve those properties. The properties on either side of Mr. Galbo are also zoned central business, even though they may be occupied residentially. Was the difficulty self-created? Well, I guess to some extent it was. CPAs are not lawyers, and the due diligence wasn't done at the time. We're trying to rectify it now. I think the biggest thing that this board should look at is how long it's been there and operating the way it's operated without any issues, without any problems. I think the last time we went over the special exception variances and requirements, if you want me to do it, I'll do it again.
No. But let me have planning
Okay.
give their recommendations.
Good evening, Madam Chair. Basically, it was a couple of years ago that Mr. Tremarco came to us and said, what do I need to do to correct what is a violation? We reviewed our old files, we saw the Diana case, and we basically told them that there was never a site plan approval and that you would need to go back to the Board of Zoning Appeals. That's what led him back to the Board of Zoning Appeals. A planning advisory report was written. It recommended removal of the garage, partly because there was concern about parking. Our job as planners is to plan for the future. It may work for the current clients, but we don't know who may be in there in the future. You may have an architect or attorney's office that's an office that has many more employees. Also, I don't think it was ever anticipated that they would meet the Suffolk County Health Department sanitary flows. It's a small site, and with an apartment and an office in the primary structure, and then with the garage. That concern appears to have been addressed, as the Health Department said that's not an issue, and the Environmental Department is now recommending a secret. So anyway, I think that was a large part of why the Planning Advisory Report was written by the director in that way. If the board determines that they would like to remain, have the garage or the office remain in the garage and that structure remain, certainly we can look at different options. We still have concerns about providing buffers to adjacent neighbors. One of the things we were looking at is, there's a 2-foot buffer to the neighbor to the east. Typically, a 10-foot buffer is required. We feel that with redesign, we can still keep the minimum of the 7 parking stalls. That is what the variance is requested, and provide probably an 8-foot buffer. Also, is there a dumpster on site, or is the garbage just taken off?
No, the garbage is removed. They have very little garbage to take away.
Please, I don't want you talking from the audience. Thank
No,
you.
there is no dumpster on the site.
The,
Okay.
with respect to...
I'm going to ask you to stop for a minute.
Okay.
Thank you.